All right, good afternoon, everybody. We've got two different hearings today. We've got the special magistrate hearing for code enforcement issues, and we also have a special magistrate hearing for variance and special exception. We'll take the code enforcement hearing matters first. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I have been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in just a few moments. In all cases, since the city has the burden of proof, the city will present its case first. The respondent then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, the city attorney will swear in any witnesses.
Speak on this matter. If you can stand up, raise your right hand, and be sworn under oath. Sir, are you going to speak?
Yes.
Raise your right hand. Swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth?
All right. The first matter on the agenda is a lien reduction request in case number 2020.065, Pelican Lane. Mr. Trask, how do you want to proceed on this one?
This being a lien reduction request, it is not a matter that's being brought to you by the city. It's a matter that's being brought to you by. Imagine that the appropriate way would be, this is his request, his petition, his application, that he would be making that presentation first, and then we would follow up with cross-examination.
I agree with that. All right, is the property owner here, the applicant? All right, sir, please step up, give us your full name and address.
I thought they were supposed to just do that, and also, they didn't tell me what to do or what not to do. If I knew this is going to be like formal like this with this, I would have brought an attorney for that matter. And they didn't tell me nothing. They just really put me in dark from the beginning, telling me something and doing something else. And now the same thing's happened.
All right, well, first of all, give me your name, sir.
Gabby Frafer.
All right. And Mr. Frafer, this is your request for a lien reduction. I've read what you've submitted. At the same point in time, if you want more time to hire an attorney or anything else like that, if you want more time to gather evidence, anything else you present to me, that's absolutely fine. I'll give you as much time as you need. We can notice this hearing for a month from now or any other time you need if you want to hire an attorney. If you want to go forward today, that's fine too. That's your choice.
Okay, but they've been delaying me for over and over, and every week, another week, last week, the week before, and we've been waiting on it, and I don't want to just lose more time, but why they didn't explain to me, why they didn't tell me, why they didn't send me some information for that matter, I don't understand. I mean, I don't know how it works, but my understanding, I should know what's going on, and now they were supposed to say what they wanted to say. Now, instead, I got to have to just, and whatever I prepare in plain English, it's sort of rebut for whatever they've been claiming that I did, which is I never done, at the first place, from day one.
All right, well, let me explain the process, sir, so you're aware. You filed an application to reduce the current amount of fines that resulted from the code enforcement hearing that we had, and that hearing was back in.
Yeah.
The hearing was on June 22nd.
22nd.
That's correct. and my order was entered on June 29th.
But, I mean,
So, hold on, sir, let me
sorry,
finish.
sorry.
So, apparently, from the documents and information I've received, you were given up to 90 days in a certain instance to bring the property into compliance. And as I told you at that hearing at that time, as I tell everyone, make sure you get with the city as soon as you're in compliance so that they can set forth that you are in compliance.
Okay.
And what the city did is they apparently went out and inspected your property around the time of the deadline for compliance,
Mm.
and you still were not in compliance. Then at a point later in time, looks like on or around 11/1/2020, at least for this first meeting, you were in full compliance. So what the city did is they took the fine that was set forth in my order, which is $250 a day for every day it wasn't corrected, and that was the amount of the lien. They say now you are in compliance. You've come before me and you've asked me to reduce that lien. There are certain factors that I'm happy to listen to anything you want to tell me as to why it wasn't in compliance, why this lien creates a hardship. Anything you want to tell me, I'm here to consider reducing that lien for you.
But also, I disagree with the lien in the first place. I was on compliance from day one, even before.
Then you're,
And that's,
but let me stop you there.
sorry.
You came up and you said you wanted more time to hire an attorney. I've explained the process to you now, what we're gonna go through today. If you want more time to prepare, to hire an attorney, to bring in other witnesses, to do anything, I'm happy to give you more time. All you have to do is tell me, and we'll go ahead and give you more time.
Okay.
The city says you're in compliance right now, so no fines are running right now, okay? So if you want more time, it's not like the meter's still running. The meter has stopped running. Now the only question is, do you fit the criteria under law to reduce the lien? If you want to move forward today, I'm prepared to hear all your arguments. If you want more time, if you want to hire an attorney, just tell me. We'll continue this to another time and you can have more time to prepare. I have to defer to the city on when they can get it renewed.
So basically, I have to go through the city to get any of those acceptance or whatever I'm gonna do, or whatever that hearing is going to be all about? Or who will decide about this normally?
I decided. So if,
No, sorry, I meant who would decide about what kind of hearing are we having here? About, reducing fine, or about canceling completely that fine, or overturn, or whatever, and explain, or actually, explaining the order that Your Honor did, 2 or 3 months ago, or whatever in there. Actually, this is the key to start with, because based on that order, we did not do anything wrong. We comply by it, plus, we told the city about it on top of that.
okay, if your argument is that you were in compliance by the compliance deadline, I'm happy to hear what you have to tell me. I'm happy to listen to other witnesses you have, look at photographs, hear your argument, whatever it is you want to argue. My question is, you came up at first and said you don't know what's going on, you would have hired an attorney. So I'm giving you a choice now. This is your application. If you want more time, please tell me, and I'm happy to give you more time. If you want to move forward today, I'm ready to move forward and listen to whatever evidence you want to give me in any form. I'm willing to consider that.
Okay.
It's your choice.
What about the date for, if we're gonna just postpone it right now?
What type of notice do you guys need if we were going to continue?
Special magistrate hearing, and the
Can we,
Hold on just one second. That'd be Christmas Day, so I don't know if we
No,
can.
January.
I mean,
Okay.
what can we do next week? I came last week, no, I mean, I had to leave again, I'm coming this week. Can we do next week? It's Monday. Or anytime this week. I'm available.
Is it open here on,
That works for me. We're talking about rescheduling it to December 7th at 2 p.m. if the chambers are available. Does that work for you?
Or, yes, sir,
Give us 1 second, let the city
no problem.
we have a meeting space, and then we'll go from
Okay, no problem. I mean, if one day before, one day after, or whatever, I have no problem, I'm flexible. Just because I was surprised, that's all.
Mr. Frafer, it looks like we can come back next Monday, December 7th, at 2 p.m. I'm going to put that on my calendar.
Okay.
And Mr. Fraser, let me give you an idea of the things that I'm going to look for and consider. Okay, number one, I'm going to hear your argument as to whether or not there was a violation that continued on the property after the date. So feel free to give me that evidence next week. If there was a violation, I'm going to consider how long it took you to correct that violation. If there was a violation after the compliance deadline. I'm going to look and see, I'm going to ask the city whether there's any prior or subsequent code violations on the property during the time you've owned the property, whether you have any other code enforcement violations on any other properties you own within the city, whether you've continued to own the property during the time that the violations occurred, what type of proactive action you took to correct the violation, and if it went beyond the deadline, were there any mitigating circumstances as to why it took longer to correct the violation? And then if there's any other information you want to give me that's specific to that property or a hardship or anything like that, I'm happy to factor those into the consideration as to whether or not to reduce the lien. So that's going to be what I'm looking for from you next week. And if you hire an attorney, anything else your attorney wants to tell me, okay?
What about if there is problems with the previous order in there, in term of document, in term of, improper, exhibits, improper things that's not properly associated in there?
Right, I'm not going to revisit my prior order. That's not going to be what happens next week.
No, I mean, there's mistakes in there, little mistakes, for example.
Tell me whatever you want to tell me about that order. Anything you want to tell me, any argument you want to make as to why the order that I entered was not correct, I'm happy to listen to that.
Yeah.
But the primary issue I'm deciding is not whether or not a violation occurred. That's been decided. I'm not going to revisit that, but I'm happy to hear what you have to say. What I'm looking for is information as to why it would not be fair to you to go ahead and say that you've got to pay the full amount of the fines that accrued on the property. And the factors I just gave you are some of the things that I'm going to consider in coming to that decision. Okay?
Okay.
All right, so we will see you next Monday, December 7th at 2 p.m. Mr. Trask, do I need to enter an order on that, or you just want to do an amended notice of hearing?
We'll just do an amended notice.
All right, and this applies also, the next case on the agenda is 2020.066. We'll continue that hearing to December 7th at 2 p.m. Also, call case 2020.067, and we will continue that case until December 7th at 2 p.m. All right, sir, so we'll see you a week from today, okay?
Thank you very much. Thank you.
All right, thank you. Is there anything else on the code enforcement agenda that I need to address today?
No.
All right, that will conclude the code enforcement special magistrate hearing today. And now we'll move into the variance and special exception special magistrate hearing. Again, welcome to the City of Madeira Beach Variance Special Exception Use Special Magistrate Hearing. My name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these variance or special exception requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be conducted in the following order. First, we will confirm that public notice has been proper. Second, the city will present its case and staff report, and the applicant may ask questions of the city's representative. Third, the applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. Next, public comment will be solicited or received from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. All public comment shall be limited to 3 minutes per person unless the city decides otherwise. Public participation will then be closed. I will deliberate and then make a decision to grant or deny each variance requested in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure we have a correct address. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a few minutes, the city attorney will administer the oath and swear in any witnesses. If you expect to talk to me today during the hearing, then you need to rise and be sworn. This includes any members of the public who are directly affected by the variance or special exception and may wish to provide public comment. Mr. Trask, can you go ahead and swear everybody in? All right, we have proper notice for everything today. Excellent. And just before we get started, are there any written objections that have been received? I don't see any.
No.
All right, then let's go ahead and call up the first one, which is variance 2020-04. Is the city ready to proceed?
Yeah.
Go ahead.
All right, Your Honor. The request is for variance, I'm sorry. Okay, right. Sorry about that. This is Linda Portal. I'm the Community Development Director for the City of Madeira Beach. I've been a practicing planner for almost 40 years and have expertise in land use and regulation, zoning, code enforcement, and have previously worked in local government and private practice. We have requests for variance for two properties that sit side by side on Gulf Boulevard. The request for variance is because the lots are a little bit smaller than would be required for the single-family use that's requested. And in fact, they're actually small for anything that would be placed there, and variance was pretty much required no matter what the request was for. The reason for the condition of the property is that all of the parcels along Gulf Boulevard were originally platted in 1934 and 35, and they were conforming at that point. They were 4,000 square foot lots, 100 by 40. But during the course of life and urban expansion, at some point the state came through and took 17 feet off the front of it to expand Gulf Boulevard. So the hardship that each of those lots experienced was as a result of roadway expansion, the right-of-way expansion. So at this point, they're interested in putting single-family homes, which is the really lowest impact use that could be allowed, and it itself is allowed under a special exception. But they're they know that they don't have the lot area that's required by the code. Specifically, section 110-320 for minimum building site area requirements relating to the C3 zoning district in the retail commercial um, that requires 4,000 square foot for a multifamily or tourist dwelling unit. Staff reviewed the request in detail, and they found that the lot, um, this particular lot is the northern of the two lots. They're identical lots side by side. The restrictions are, as I said, related to the residential use, and the only thing that does not have that 4,000 square foot lot requirement is the multifamily tourist. And you can imagine how difficult it would be to build multifamily tourists on a 3320 lot either. So it's especially since any other use would have more maneuvering and backing out onto potential. So there are, of course, findings that must be made in the review variance request, and staff review finds substandard irregular lot was not caused by the property owner, but is a condition that was that caused by government action over the life of the property. There's a residential neighborhood character in the area on both the north and the south of these two lots. There are residential uses, and abutting against the back end of the lots are also other residential uses. The district is of a mixed use, and so as you go up and down Gulf Boulevard, you see there's retail and office and a lot of tourist activities, but also residential scattered all the way along Gulf Boulevard. There's not a whole lot of single family, but there has been in the past. There are a few here and there. And some of the commercial establishments are originally, you can tell looking at the buildings, built as single family. The architectural character that would be proposed here is going to be similar in height and bulk and mass as anything else that could be placed on that property. Of course, anything that they do would bring it closer into compliance because we're going to have to look very carefully at the parking and maneuvering activity on the lot. And so this is not, so it does not give a special privilege to this piece of property, as all the other properties with the same dimensions have already been built out in various uses over time. And as I said, this is actually the lowest intensity use that could be requested. The literal interpretation would deprive the applicant of any reasonable use, honestly, because even if you were to try to put the multifamily tourists on there, it would be really difficult to manage with the amount of parking that would be required. Variance is the minimum that could possibly be used on the land. And the granting of variance is in harmony with the general intent and purpose of the city's land development regulations. Specifically, it will facilitate construction of a code-compliant structure to a scale similar to that surrounding in the mixed-use district. Finally, the staff found that since the single-family uses are more sensitive to noise and congestion than is characteristic of other mixed-use activities, we're suggesting that the developer should be required to provide fencing and other landscaping along the property line, especially on the sides and the rear, and in particular there. Also, design the site to ensure maneuvering of vehicles for the entrance and access happens on site, that they're not backing out onto Gulf Boulevard. That would be a problem for the state as well. We do want to make the point that when you put single family in a noisy area, even though people are buying into that situation, they will sometimes come back and complain that it's so that's the purpose of making sure lots and put some landscaping in the back. It actually protects the other uses as well from, just complaints. Staff then recommends the approval of the variance, um, reduce the required lot area for the single-family development, 1,320 square feet for the, parcel ending in 0060, with the condition that fencing and landscaping, planting to, adequate to provide buffering from the surrounding uses be provided for a certificate of occupancy, and that the driveway access be designed to ensure that maneuvering does not occur on Gulf Boulevard.
All right, I'll go ahead and accept into evidence as Exhibit 1, pages 3 through 27 of the agenda packet. Mr. Trask, is there anything else you want from Ms. Portal?
Yes. That's correct. Yes. Yes, it was.
All right, is the petitioner here? Anyone on behalf of Edward and Karen Smith LLC? Come on up to the microphone. And before you tell me anything else, give me your name.
My name is Cameron Smith.
Cameron Smith?
Yes.
All right, and Mr. Smith, what is your relationship or capacity in regard to Edward and Karen Smith LLC?
That's my parents. I'm owner of a general contractor.
Okay, I'll just say a representative of the owner. How's that sound?
Yes, sir. That's perfect.
Okay, hold on just 1 second. All right, Mr. Smith, the city is recommending approval of this variance. It looks pretty straightforward to me. The approval is subject to the conditions Ms. Portal just set out. At this point in the hearing, you have the right to ask Ms. Portal any questions you want to ask. I'm going to give you an opportunity in just a few minutes to tell me anything else you want to tell me, but this is your chance to ask her any questions. Do you have any questions for her?
I do not.
All right, sit right there, sir. Just stand right there for a minute. All right, Mr. Trask, anything else on behalf of the city? All right, Mr. Smith, what else is it, if anything you'd like to tell me, anything you want to share with me, anything like that?
I live on Madeira Beach, born and raised. Nobody built a better house. Promise you that. Really it.
All right, and Mr. Smith, do you or anyone on behalf of the petitioner have any objections or problems with the conditions that have been placed on here? We've talked about fencing and adequate landscaping, and also that the driveway access and parking be designed to ensure the maneuvering of vehicles to allow for direct forward access to Gulf Boulevard.
No, not at all. It'll be beautiful.
Okay. All right, sir. That's Mr. Trask, you have any questions? Okay.
Good.
All right. Mr. Smith, have a seat, but
Thank you.
don't go far.
Yes, sir.
All right. At this point in time, we've heard from the city and we've heard from the petitioner. Are there any members of the public that would like to provide comment in regard to variance 2020-04? Seeing no member of the public coming forward to comment, Mr. Trask, I'll go back to you. Is there anything else you'd like to present? All right, I'm going to go ahead and find that all of the criteria have been met to grant this variance and to reduce the required lot area from 4,000 feet to 3,320 square feet. The conditions will be that fencing and landscape plantings are adequate to provide buffering from surrounding uses be provided before certificate of occupancy, and that driveway access and parking be designed to ensure all maneuvering of vehicles to allow for direct forward access to Gulf Boulevard be provided on site. Anything else in regard to variance 2020-04, Mr. Trask? Let's move on to variance 2020-05.
This is a similar variance request. It's a variance request to reduce the lot area listed under section 110-320. It requires 4,000 square foot minimum for residential lots, and to reduce that to a 3,320 foot lot. As was explained before, the lots along this portion of Gulf Boulevard were originally platted in the mid-1930s, and at that time were conforming with a lot area total of 4,000 square feet. However, over time, the state came through and expanded Gulf Boulevard and the right-of-way, and in so doing took 17 feet from the front of each of those properties, making them non-conforming for most uses listed in the district. Thus, the lot so the variance is requested because the minimum lot area is not adequate to build anything except tourist accommodations, and even those would be very difficult because of the amount of parking and maneuvering that would be associated with those uses. And what is requested is the minimum allowed with special exception under that zoning district, the C3 district, of a single-family home. In its analysis, the city found as follows: that the special condition is peculiar to this property or the string of properties in this particular area along Gulf Boulevard, in that it doesn't apply generally to lands and buildings elsewhere in the district. Its special condition exists because the lot area is irregular and substandard based on actions of the government in taking property for right-of-way expansion, that the residential character of the neighborhood would not be threatened. These lots are surrounded on all sides by residential uses and of a fairly low density and structural type, and that the proposed single-family dwelling that would be accommodated by this variance would be consistent with that architectural standard. The special engineering and architectural conditions that exist other than just the design of residential structures in the area included the difficulty of maneuvering on Gulf Boulevard, but this can be resolved with conditions that have been proposed. That the special condition circumstance does not result from the actions of the applicant, as explained. The granting of the variance will not confer on the subject any special privilege. In fact, all of the other lots in this area that have been similarly reduced have always been allowed to build and are all built out, mostly with residential use in the immediate surrounding area. So we would be granting them the bare minimum of density compared to things that have been granted around it. Literal interpretation would deprive the applicant of the right commonly enjoyed by those properties, as they have all been built out, and because the properties individually would be very difficult to build by the supposed allowed use of tourism or multifamily, because it has greater impact than that they're requesting. The variance granted is the minimum variance, as this is the smallest or the largest the lot can be. It's 3,320 that cannot be expanded, and they are asking for the minimum density allowed in the district. The granting of variance will be in harmony and general intent with the purpose of the city land development regulations and the comprehensive plan, in that the variance will facilitate construction of a code-compliant structure to a scale that is similar to surrounding the site in the same district. And finally, the single-family, use is more sensitive and, to noise congestion characteristic of a mixed-use district, and that because of this, we are recommending that with fencing and landscaping, some buffering would be provided to protect the single-family use and hopefully reduce complaints, about those kind of nuisance complaints that come with noise. And then also to ensure safety that, maneuvering the vehicle would happen entirely on the property, allowing people to exit going forward onto Gulf Boulevard. Those things can be handled with conditions, to the variance approval, and so do not stand as a hindrance to moving forward. Staff recommends the approval of variance 2020-05 to reduce the required lot area of single family from 4,000 to 3,320 square feet for the parcel ending in ID 0070, with conditions that fencing and landscape planting adequate to provide buffering for surrounding uses be provided before the certificate of occupancy, and that the driveway access and parking be designed to ensure all maneuvering of vehicles, is allowed for direct, forward access to Gulf Boulevard.
Go ahead, Mr. Trask.
Yes. Yes, it was.
All right, I'll go ahead and accept into evidence as exhibit number 1 the portions of the agenda packet that are designated pages 28 through 52. Mr. Smith, come on back up. Just as in the last hearing, you heard that the city is recommending approval of this variance. However, you have the right to cross-examine Ms. Portal. Are there any questions you'd like to ask?
None.
All right, very good, sir. Anything else you want to tell me about this variance?
Be another beautiful house.
Okay, sounds good. And do you understand and agree to the conditions that the city has set forth
I do.
in regard to fencing and traffic?
I do.
All right, Mr. Trask? All right, thank you, sir. You can have a seat, but don't go far. Okay, are there any members of the public that would like to come forward and comment in regard to variance 2020-05? Seeing no members of the public coming forward, we'll go ahead and close public comment. Mr. Trask, anything else? All right, I go ahead and I'm going to find that the applicant has met all of the criteria to go ahead and grant variance that is requested to reduce the minimum lot size as requested, and also impose the conditions set forth in the staff recommendation in regard to fencing and landscape plantings, and also the driveway access and parking design as set forth in the variance. All right, let's move on to the special exception request. We'll have the first case is SMSE 2020-03. Is the city prepared to proceed? Go ahead, Mr. Trask.
Request before you is for a special exception in the C3 district. Single-family uses are allowed by special exception and must meet all the criteria required for special exceptions. And this is the point in this application, is the intent to put a single-family dwelling on a piece of property in the C3. The request that we accept the 40 by 83-foot lot fronting on Gulf Boulevard and located in the residential office retail category of the future land use element and the retail commercial C3 zoning district as an allowable location for a single-family home. The special exception has several criteria, as I mentioned, and the staff has reviewed. Single-family residential use is permitted by special exception, as is required by the code. Review of all requirements under 110, 124B. The use is so designed and located and proposed to be operated that the public health, safety, and welfare and convenience will be protected. In fact, this property has been vacated and at one point under previous ownership was abandoned and left in very poor condition. The city has had to go in with considerable expense to itself and proceed legally to recoup that once the property, to secure the property and maintain it over time. And so it would be considerably preferable for it to be built on and occupied than to remain vacant and an attraction, nuisance attraction. The use will not cause substantial injury to the value of other property owners. Again, it would actually enhance the property value of the area to be built with standard homes that meet all of the conditions for hurricane and other building code requirements. It would eliminate the vacant and at times blighted site of the abandoned lot. The use will be compatible with adjoining development and proposed character of the district. What is proposed as single family would be similar in character and architectural style as that which is surrounding it, all of which is immediately surrounding being residential and low intensity uses. The adequate landscaping and screening is provided as required in the land development regulations. So this will be enforced during the site plan development phase, and under the variance that's approved for this parcel, they would be required to add adequate fencing and landscaping to act as a buffer. Next criteria is if the adequate off-street parking and loading is provided. Ingress egress is so designed as to cause minimum interference with traffic or abutting streets. The single-family use will conform to the parking standards in section 110.971 in terms of the number of spaces, and the variance requirements associated with this parcel do require that all maneuvering be handled on-site to allow for direct forward access to Gulf Boulevard. The use would conform to all applicable regulations governing the district where located, except as may otherwise be allowed. Use would conform to all applicable district requirements other than it has a variance for the square feet lot area required. A variance is also desired. It has been applied for, and as you know, we have just recently heard the case on the variance, and it has been allowed to provide that the lot area on the site be 3,320 square feet instead of the normal 4,000 for a single-family development. The special condition use will not grant to the land more privilege than the best available in the zoning district. In fact, what's requested here is the lowest intensity and lowest use allowed. And no application of special exception use should considered by the special magistrate until the applicant has paid all outstanding charges, fees, interest, fines, and penalties. There are no unpaid fines or fees or penalties associated with this. There was a lien on the property previously, as I described, because of safety concerns and the city's fencing and maintenance of the property, but those have all been satisfied. And so the staff recommends approval based on the applicant meeting all criteria for the special exception, with the following conditions: that landscaping be placed and designed to minimize the impact of surrounding area, and that the parking and drive access be designed to minimize maneuvering on Gulf Boulevard, and that specifically drivers are not required to back directly onto Gulf Boulevard.
Anything else?
Yes, it was.
Ms. Portal, just out of curiosity, what was the prior use of the property? I see what looks like a foundation outline.
Yeah.
What was that?
I don't know what was there historically. It's been vacant a very long time, but they did have a PD approved for a 6-unit condominium, and they had begun doing the work. They had put some helix and foundational work into the ground, and then ran out of money at some point, and then it got handed off over and over again. At one point, they were keeping their permit alive by moving the dirt every 6 months, and had dug a great big hole in the middle of it, which was actually a considerable hazard, and that's the point. It was probably originally residential.
Mr. Smith, I assume you're gonna come back up on behalf of the applicant here. Mr. Smith, just like in the variance proceedings, the city's recommending approval of this special exception to let you have a single-family residence on this lot. Do you have any questions for Ms. Portal?
I do not.
All right, this is your anything else, Mr. Trask, for Ms. Portal? Okay. Mr. Smith, is there anything you want to tell me about special exception, application 2020-03?
No.
All right, and by the way, I'll go ahead and accept into evidence as exhibit number 1, pages 53 through 77 of the agenda packet. Mr. Smith, you understand the city is recommending approval, but they're asking me to place the 2 conditions, which are similar to the prior conditions for the variance, that the required landscaping be placed and designed to minimize the impacts of the surrounding uses on the proposed single-family structure, and that parking and driveway access be designed to minimize the maneuvering on Gulf Boulevard, and that specifically drivers are not required to back directly into Gulf Boulevard.
Yes, sir.
Do you have any objections or problems with those recommendations and conditions?
No problems.
All right, Mr. Trask? All right. At this point in time, we'll open the floor to public comment. Are there any members of the public that would like to come forward and comment in regard to SMSE 2020-03? Seeing no members of the public coming forward, we'll go ahead and close public comment. Anything else from the city? All right, I'm going to go ahead and find that the applicant has met all of the criteria set forth in the ordinances to grant the special exception that is requested. Therefore, I will go ahead and grant the special exception, subject to the conditions recommended by the staff, which is that the required landscaping be placed and designed to minimize the impacts of the surrounding uses on the proposed single-family structure, and that parking and driveway access be designed to minimize the maneuvering on Gulf Boulevard, and that specifically drivers are not required to back directly onto Gulf Boulevard. Let's move on to SMSE 2020-04. Is the city prepared to proceed? Go ahead, Mr. Trask.
The request is for a special exception for a single-family dwelling unit as provided by the Land Development Code, Chapter 110, Article 7, Division 7, C3 Retail District, that allows single-family or duplex by special exception. In this particular case, the applicant is requesting the special exception for use on a 40-foot by 83-foot lot fronting on Gulf Boulevard and located in the residential office retail category and the future land use in the future land use element in the future land use map and the retail commercial C3 zoning district. Special exceptions, the code does require that the special magistrate make certain findings to ensure that special exception conditions are met, and the staff has reviewed these and makes the recommended findings as follows. That the use is permitted by special exception, that's the first criteria, and it is listed in the section of code previously cited for the C3 as a special exception use. That the use is so designed, located, and proposed to be operated that the public safety, welfare, and convenience will be protected. In fact, it would be a help to have this developed. It's a very minimal development density that's being requested given the size of the lot, but it would be a relief to the city if these previously abandoned lots were developed to prevent blight and also just the attractive nuisance of vacant properties. The city has expended considerable effort and funds over time securing the property. That the use will not cause substantial injury to the value of other properties in the neighborhood. In fact, we believe that it should enhance the property values of surrounding properties, which are also designated or in use as residential uses, just in that they will not be in the same vicinity as vacant or abandoned property. And also that whatever is built will be built into conforming standards for hurricane and other building code requirements. That the use will be compatible with adjoining development. As stated, it is surrounded by other residential uses that are of a low intensity design and impact. And that the adequate landscaping and screening could be provided as required by the land development regulation. And in fact, in this case, the staff is recommending that it be specified in this special exception that the developer will provide landscaping and fencing to protect surrounding uses and also this proposed use from the impacts of development at different intensities, noise and things of that nature in this mixed-use area, that it be in placement, it will be in keeping with the site plan design that's brought in and will be in place before the certificate of occupancy. The adequate off-street parking and loading be provided. In fact, the staff is also requesting that in recognition of this property being directly accessible to Gulf Boulevard, that all maneuvering for parking be conducted on-site so that those leaving the property can do so in a forward direction. That the use conforms with all applicable regulations governing the district where it's located, except as allowed for a planned development. This is a standard use. The only condition that it differs for is the lot area that's required for single family. Normally that would be 4,000 square foot, but this property has a variance approved to reduce that to 3,320 square feet. And that is covered in the next point finding, and that is that the variance has already been applied for and been approved for the property, addressing the lot area. If the special exception use is not granted, the land more privileged than that available throughout the zoning district, and in fact, the single-family use does not grant the land more privilege or best available zoning, but is the lowest intensity use allowed in the category. That the applicant for special exception use shall be considered by the magistrate only when all fees are paid, fines, interest, penalties, or anything owed to the city by the property owner have been removed, and in this case there are no outstanding fines or fees that the liens that were associated with this property and previous owners have been resolved. The staff therefore recommends approval based on the applicant meeting all the criteria for special exception with the following conditions: that the required landscaping be placed and designed to minimize the impact of surrounding uses on the proposed single-family structure, and that parking and driveway access be designed to minimize maneuvering on Gulf Boulevard, and that specifically drivers are not required to back onto Gulf Boulevard.
Else on this one?
Yes.
All right, I'll go ahead and accept into evidence in the record as exhibit number 1 the items from the agenda packet that are designated as pages 78 through 102. Mr. Smith, come on forward one more time. Mr. Smith is in the prior hearings. This is your opportunity to cross-examine and ask Ms. Portal any questions you want to ask. As you heard, they're recommending approval with the same conditions as the other special exception for the other lot. Do you have any questions for Ms. Portal?
No, I do not.
Mr. Trask, anything else from Ms. Portal? All right, Mr. Smith, you understand the staff is recommending approval, the same 2 conditions in regard to landscaping and parking and driveway placement exist. Do you have any objections?
No, sir. No, sir.
Okay. Mr. Smith, out of curiosity, what was on the property before?
I guess they're going to build like a 6-story building, and I guess they're going to do some underground parking, and that's where that big thing happened, a big cave, and, so I took it off their hands, and like I said, somebody who lives here, born and raised here, you know, I take pride in my beach, and it's just gonna be really two beautiful homes going up.
And are you the builder or developer?
Yes, yes,
Okay,
yes,
very good.
sir.
All right, Mr. Trask, any questions based on what I just asked Mr. Smith? All right, Mr. Smith, thank you, have a seat.
Thank you.
At this point in the proceeding, we'll accept any public comment from any members of the public that want to comment in regard to SMSE 2020-04. Any members of the public? Seeing none, we will go ahead and close public comment. Anything else from the city before I rule? All right, I find that the applicant has met all of the required criteria for granting the special exception that was requested, and so I'll go ahead and conclude that the applicant is entitled to special exception with the following conditions: that the required landscaping be placed and designed to minimize the impacts of surrounding uses on the proposed single-family structure, and two, that parking and driveway access be designed to minimize the maneuvering on Gulf Boulevard, and that specifically drivers are not required to back directly onto Gulf Boulevard. Anything else before me today in regard to the variance or special exception agenda? All right, that will go ahead and conclude all the special magistrate hearings for today. I'll go ahead and reduce these orders to writing. Mr. Smith, do you want your order sent to 11874 Walker Avenue, Seminole, Florida? Okay, that's where I'll mail all of them to you at that address, and the city will have the original, okay? All right, that concludes the hearing for today.